I will try and be fast as I can and read some of the details of this consent judgment because I have a copy of it with me. The CTC, as you call it. So, in the Magistrate Court of Lagos State, in the Ikorodu Magistral District, holding at Court 1, Ikorodu Family Court, today, Tuesday, the 24th day of October 2024, before our honor, Mrs. A.B. Olagbegi Adelabu, Chief Magistrate Admin. The suit number is there, and this is the matter here. The matter of the paternity test of Master Liam Aloba for and on behalf of the family of Mr. Ilerioluwa Aloba deceased, represented by his father, Mr. Joseph Aloba. And this suit is between Mr. Joseph Aloba, the applicant, and Mrs. Wunmi Cynthia Adebanjo, the respondent. And appearing for these people, appearing in the court, you have the names of the lawyers for the applicants. There you have Monisola Odumosu, I'm sure representing his dad. And you have the respondent's lawyer too. So it's titled Consent Judgment. Number 1. Whereas the applicant instituted this action via an originating motion dated 19th of February 2024. That's when he initiated or instituted this suit, wherein he is seeking the following release. These are the issues he brought to the court. A. An order of his honorable court directing that a DNA test is conducted or be conducted in relation to the paternity of Master Liam Aloba, being an alleged son of Mr. Ilerioluwa Promise Oladimeji Aloba deceased, in a recognized and accredited government or private medical facility within the Lagos State, Nigeria, at the expense of the applicant, meaning he was ready to pay for this DNA test. 2. That an order directing Mrs. Wunmi Cynthia Adebanjo to submit herself and Master Liam Aloba for the DNA test at any recognized and accredited government or private medical facility within Lagos State, Nigeria, at the expense of the applicant, still ready to pay for it. C. An order granting leave to the chief medical officer or chief pathologist in charge of the remains of Mr. Ilerioluwa Promise Aloba deceased, presently at the military hospital Yaba, Lagos, to remove any tissue or hair or any part of the body of the deceased to conduct a DNA test for Master Liam Aloba. And D. And such further or other orders as the Honorable Court may deem fit to make in these circumstances. So these are the 4 reliefs he brought before the Magistrate Court. 2. The respondent, being served with the originating processes, filed a preliminary objection dated 10th day of May 2024. The applicant filed a counter affidavit and a written affidavit dated 3rd June 2024, almost 1 month later, before he filed his own counter affidavit. 4. The respondent, in response to the applicant's counter affidavit, filed a reply on point of law dated 13th of June 2024, 10 days after. You can see who wants this thing done and who is trying to buy time here. Number 5, we will come to number 4 back, but number 5 first. The parties, being desirous of resolving the matter amicably, have agreed to settle this suit on the terms set out herein on the 11th of October 2024 by parties and their counsel. So I'll pause here and do a little bit of talking so that we can add 1 + 1 together here. So we saw that he brought this suit in February. There was some back and forth between February and June. And on the 13th of June, when a point of law was raised, that point 4 said the respondent, in response to the applicant's counter affidavit, filed a reply on point of law. Meaning, all this while, Joseph Aloba said he wants to do this. The lawyer said, no, if you say you want to do this, go and bring this, you go and do that, you go and do that. He filed a counter response again that, no, I don't want to do this, but you have to do this. Then Wunmi's lawyer now raised a point of law, meaning you don't even have the legal right to ask for this. Why are you asking for this? Show us the law that grants you the power to get this. That is an argument on the point of law. And that was where everything went south for them. Because there was no law to show. There was nothing to bring to support what they want. Then that is when they now started buying time. That was when you start seeing Josie moving from one interviewer to the other, calling Liam name, calling Wunmi names. Before he was now brought to the court again, and he was cautioned. That was when for some time you didn't hear him speaking about DNA at all, and he was trying to avoid the matter as a whole, because he was cautioned by the courts. Though he was not given a direct gag order, but he was cautioned that if he speaks of this of that issue again, he will be seriously sanctioned then. So the court, being a family court, they nudged them to try and find a settlement to this because of the issue the respondent lawyer raised. It was an issue of law. Then the court told them, have you decided that you want to continue with this? Is it that there is no agreement you can reach to find a solution to this before I make my ruling? Because now the lawyer has called on the judge to bring forth, because if you are as a judge, you want to make a ruling on a case, you must support your ruling with either a judicial precedence, meaning a previous case that has been decided upon, a related case that has been decided upon. You need to show forth that, oh, based on this case that was decided upon, I'm also aligning myself to that ruling, therefore I'm making this ruling. Or you quote a law supporting your decision to make that ruling. But because there was no law to quote and there was no decided case regarding this kind of issue, the judge nudged them, do you want to look for something to agree on? Do you want to find common grounds here or not? Or I should make my judgment? Then they went to the negotiating table, if you want to put it that way. Then some terms of settlement were set forth. And that's what we'll be reading now. A, that the respondent hereby consent to submit herself and her son, Master Liam Aloba, for the conduct of DNA tests at 2 recognized and accredited government or private medical facilities within Lagos State or other agreeable hospital outside Lagos State. 2 hospitals within recognized and accredited government or private within Lagos State or other agreeable hospital outside Lagos State. If it's outside Lagos State, they have to agree on it. That is the meaning of that number 1 terms. Agreed upon by the respondent, which is Wunmi. B, the applicant shall bear the cost of the DNA testing, the process, including the fees for testing, facility, the collection of sample, and any other associated legal or administrative fees. C, that the DNA test shall be conducted at a mutually agreed upon laboratory or medical center, one of which may be within Lagos State and another at a well-recognized hospital or laboratory outside Lagos State but in Nigeria, to ensure and ascertain the reliability of the test. E, that the applicant and the respondent agreed that the said DNA test, excuse me, hold on. Sorry. So, E, that the applicant and the respondent agreed that the said DNA test of Master Liam Aloba shall be under strict supervision of an appointed officer of the Honorable Court. Both parties, that's F, both parties to this understanding hereby agreed in advance that they will accept the result of the DNA test as a conclusive evidence of paternity. E, parental responsibilities of the applicant's family shall ensure that the child in issue is given full parental support, such as child support or other legal responsibilities based on the outcome of the test. I don't even think Josie has enough money for his own support. H. The respondent agree not to deny the applicant from being part of Master Liam Aloba's life. The parties hereby agree that this term of settlement shall be the judgment of the court, and it shall be binding on all parties, including their legal representatives and assigns. So basically, those are the key agreements that they reached, that they presented to the court, that the court should ratify it for them. So on 24th day of October 2024, the parties were present. The applicant was physically present, that's in the court, while the respondent, Wunmi, was present virtually. So when the story got out then that, the judge had to call Wunmi on phone or on video call and things like that, and people were saying it was a lie, you have it here in the CTC. She was present virtually. A video call was put across to her just to confirm her readiness and to be sure she was not coerced into agreeing to these terms. 7. The parties and their counsel confirm that they signed the terms of settlement. Both counsel further agreed and urged the Honorable Court to make an order specifically that the Chief Medical Officer, Chief Pathologist in charge of the remains of Mr. Ileri Oluwa Promise Oladimeji Aloba disease, presently at the Military Hospital Yaba, Lagos, is to remove any tissue, any part of the body or any part of the body of the deceased for the purpose of conducting a DNA test for Master Liam Aloba, pursuant to prayer C on the originating motion. So these are the major agreements. So now, after all these agreements was made and it was tendered to the Honorable Magistrate, so after everything was tendered to the Honorable Magistrate, the magistrate had to decide if everything was fine and if she was okay with the terms they agreed on. So 8. Accordingly, since this is a family court as well as a family court matter, where a social worker and social welfare officer can conduct a social inquiry under oath, or upon affirmation, upon the application or agreement. So basically, what here is saying is that the judge had to assign a social worker to this case, which I will not mention his name here now, so that that person will be the one monitoring the performance of this agreement here to ensure that everything was done or is conducted in line with what the court what they agreed upon and what the judgment of the court, the court gave. So we'll now go to 14 of it. Finally, this is the judge speaking here now. Finally, even though the 23-page ruling of this honorable court is ready to be delivered, even though the 23-page ruling of this honorable court is ready to be delivered, that has now been overtaken by events, since the parties not only filed a terms of settlement endorsed by parties and their representatives, parties and their counsels have also made additional agreements in the open courts. And this honorable court, being in full support of alternative dispute resolution, ADR, is pleased with the conclusion of the mediation, which resulted in parties filing terms of settlement with additional agreements in an open court, indicating clearly that litigants now agree with each other. You might not understand. Let me explain that number 14 for you. So the judge, after, don't forget that in June 13, the lawyer for the respondent raised an objection from the point of law, saying that where is the law supporting what this man is asking for? Where is the precedent supporting it? And then the court urged them to go for alternative dispute resolution. Now they came back with an agreement. But before they came back in October, remember, they raised this point in June. June to October is like more than 3 to 4 months here now. The court already all this while, the court has created a 23-page judgment that the court wants to rule, like, when next you guys come to the court and I don't have an agreement, this will be my ruling. 23-page already. So, but because they now came back to the judge with a terms of settlement, that judgment became mute. The judgment became moot. That is, the judge can no longer deliver that judgment because both parties, they have now agreed. They have listed what I want, what you want. They have listed it out. The process of listing, of getting that final document was all this while when Josie was saying he wants this, he wants that. Even in the open court there, that day, he had to make some things, but the court had to strike those ones out. For example, he was saying he had paid a particular pathologist to conduct this DNA test. And an objection was immediately raised by Wunmi's lawyer there that they are not going to accept that. And the court agreed to that. And the court told him to not to go ahead with that. Whichever pathologist they have paid, because the court noted that that will be working towards an answer. The court agreed that that would be Josie and his team working towards an answer. If you had already paid a pathologist already to do a job for you, a job you have not, the court has not given you the go-ahead to give to him. So it could imply that you have bribed the pathologist, and all he will be doing is trying, he has the answer already, he only wants to show what is there. And the court objected to that too. Part of it, before they got to that same final terms of settlement, we had different terms in there too that they put forward. For example, that the result of this particular DNA test that they will do, that the result should not come to the public. They wanted to gag Wunmi and a representative, that's a lawyer, not to bring this to the public, not to talk about it. That once the result comes out, everybody should just go their way, which they also objected and was taken out of this agreement also. Another thing they also raised there was that Wunmi should surrender his right to sue or petition or exercise any form of relief or remedy regarding the defamation, both criminal and civil defamation of her name by Joseph Aloba. They were asking her to surrender that right, not to sue Joseph Aloba after this DNA testing. The lawyer objected to that also, and that was also removed from the terms of settlement. Amongst other things, other issues that you will see and you will feel like, where is this coming from? All these were removed from that terms of settlement, and after they have agreed to other ones, they brought it to the judge, and in the open court there, they made other arrangements, also other agreements in the open court along with these terms of settlement I've just read out. Like, for example, you will go to 2 different hospitals within Lagos State, and if it's going to be outside Lagos State, it will be agreed upon by both parties. Agreement like you will not use the pathologist you have paid money to initially, which is what's the name of that hospital again now? This hospital at Ibadan. UCH. You will still see that in other correspondence that if we have the time, we'll still read out this evening. So the judge now said, okay, I have reviewed this. You guys are happy with it. I am happy with it. I will set aside my 23-page ruling that has already been prepared and is ready to be delivered. So accordingly, upon the application of the lead counsel for the parties, terms of settlement dated 11th of October 2024, endorsed by parties and their counsels, as well as the additional terms agreed to in the open court. So it means not just these terms I've read out now. There are other things, terms agreed to in the open court, that nobody can gag Wunmi, for example, from not suing or not disclosing the results of this DNA once it is out. That along with these terms that was agreed to in an open court on the 24th of October 2024 by the counsels for both parties as well as the parties enumerated above, all these are hereby adopted and entered as judgment of this honorable court. End of matter. Signed and stamped by the judge, the clerk, and everybody that needs to sign it. So this is the certified true copy of the event and the ruling of the on the DNA test. The suit that was brought by Joseph Aloba after many months, after defaming Omomi, after calling her names, after he has refused. So that judgment was given, that consent judgment. So for those that don't know, now you know that this judgment was based solely on the wills of Omomi, on what she wanted out of this. She wanted the public to know, since they, according to Joseph Aloba, since they have asked about this, she wanted them to know the true state of things on this, and she accepted to submit herself to a DNA testing, and her son also. She also agreed that they will do this at 2 separate hospitals, accredited hospitals. But then she did not agree not to come back to the public to let them know the result of this test. She did not agree not to sue Joseph Aloba if and when she feels like suing him over any statement he has made in the past or he will be making in the future regarding defamation of her character and the character of her child. So that judgment was reached. They agreed on that on 24th of October 2024. And since then, Joseph Aloba has been running from pillar to post, trying to avoid his commitment on this issue. He has been trying to avoid conducting this DNA test. Maybe he's been enjoying the fame or the money he's getting from the public. Because we believe that once this DNA test is done, a lot of things will be put to rest. Because most people up to now, if you ask them, they will say, oh, I want to look at Mohbad. I want to see maybe more fun. That is what most people will say. So if we are able to really narrow it down, to really ascertain that this boy is either this or this, then we can really know if we are still to pursue this Anwale, or we are to look somewhere else for the for those who still feel there is really a conspiracy by the members, by the friends of Mohbad, those people who are torn with him, those people who were running etasketa when the incident happened. So if you still believe those people that there's a conspiracy between them, that there's like there's a conspiracy of silence or a conspiracy to buy Mohbad, once you have the result of this DNA test, then we can really say for sure, oh, that's something. I will try and read as much, I will try and be fast as I can and read some of the details of this consent judgment, because I have a copy of it with me. The CTC, as you call it. So, in the Magistrate Court of Lagos State, in the Ikorodu Magistrate District,